should you have any questions that you would like to submit during the event, you can submit those through the question and answer space. If we cannot address your questions during today's webinar, we will follow up. Also, please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note that we can only issue CLE credit for attendance during the live broadcast of the webinar. Participation in the live webinar must be on a computer or a laptop device. Credit is not available for joining via a mobile device. And one other important housekeeping note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word that will be given during the program. When prompted, you're going to need to enter that code word into the Q&A section of the screen. If you do not have a license in any of these states, you can disregard my message. We can flip to the first slide and the second. And now for a non-housekeeping welcome. Thank you so much for joining here today. You can see the agenda on the slide. We're gathered here today to engage in meaningful discussions that are both timely and critical. We're going to delve into the complexities of the FTC's regulations on, well, Green Guide regulations, including on recycling. We're going to explore how California's legal framework influences practices now across the nation. And we're also going to examine recent litigation trends, which serve as both a warning and a guide for businesses that are navigating this intricate terrain. We are also here to provide insights and practical advice and consideration for your business operations. By adhering to the guidance that you hear today, companies can make responsible choices and truthful recycling claims that will help to promote legal compliance. Of course, failure to do so could result in penalties, legal action, and reputational damage. Talk a little bit about that too. We again encourage you to ask questions by clicking on the Q&A icon in your Zoom, and if we have time to, we will respond. So we can go to the next slide.
Thank you, Sarah. And the next slide, great. So I'm Gary Roberts. Nice to see you all. I'm a partner in the Denton's Los Angeles office, and I have spent a significant amount of time assisting clients on recycling issues. Starting out just as a table setting with the definition of recycling, I have identified this as kind of three different types of recycling. Traditional recycling is, the process of collecting, sorting, cleaning, treating, and reconstituting materials that would otherwise be disposed of and returning them to economic use or practical use in the form of recovered material. So that's kind of the core of recycling. There are two types of recycling that have received separate treatment in California and in some of the policy discussions outside of California. One is offshore recycling, which is disfavored by some, including the state of California. And the third is chemical recycling, which is disfavored by some, including policymakers in California. Next slide. Back to Sarah.
Thank you. And I realized that I did not tell you the office that I am in. I am in San Diego, so just south of Gary, and I'm a new Californian. So I'm getting used to these California guidelines, and I still think like a Midwest person, so you might hear that come out a bit during this discussion. For now, though, we're going to talk about federal law and FTC guidance. So if you can turn to the next slide, please. We know that the FTC, in fact, I think a year ago, I gave a CLE on this topic, that the FTC had solicited public comments on updates to the Green Guides. and they closed those comments in April 2023. And we know they received over 7,000 responses, and you can look at them. Actually, you could go to the FTC website and see what those responses are. But as we sit here today, the revised green guides haven't come out, and so they are still pending. So they were last revised in 2012. We want them to be revised about every 10 years. Some business industry stakeholders want it more frequently, and we're waiting for them to come out. But while we wait, I've listed on this slide some of the things that the FTC is at least attempting to do. And after our meeting today, you may wonder if it's possible to harmonize an emerging patchwork of local and state laws through federal standards, because Gary's going to tell you about all of the very onerous California standards. That having been said, it's very complicated and difficult for companies to traverse selling their products on a national landscape when we have stricter state guidelines and different rules for different states. So it's obviously it's a big priority to industry to start getting some national cohesive guidance. So that is something that they are looking for. As you know, or as you may know, for recycling claims under the FTC, the prior green guides, you have to have an availability of 60% of the recycling facilities to make a unqualified recyclable claim. And so they're looking to build a national clearinghouse so we know where we are. There are recycling facilities. Folks are looking for what's the difference between an instruction and a claim. Obviously, claims are scrutinized by the FTC and they have to have substantiation. An instruction, moreover, is simply that, telling a consumer what they have to do in order to recycle their product. There are this particular CLE is focused on recycling, but the green guides themselves cover other topics like sustainability, carbon neutrality, and things like that. And I'm not going to delve too deeply into that today. And then finally, there's questions, and as Gary just alluded to, there's 3 different types of recycling in Gary's categorization framework. There's questions around the new guidelines as to whether or not this sort of fancy new non-mechanical recycling should be included as a concept nationally in recycling, but the trend is not to consider it as such because there's very low availability. And I think I read that, one of the very small number of centers who do this has already shut down because of lack of profitability. And so there is skepticism from the agencies and from the states, as you'll hear, that this is going to turn into a solution for our recycling process or crisis. So we could move to the next slide. So because we're still stuck with the 2012 green guides, I'm just going to give some important reminders while we wait. I promise whoever wants to talk to me about the new green guides once they roll out, give me a call. But for right now, what we know from the 2012 guides is, you can't make a recycled content claim unless your material is actually recovered or diverted from the waste stream. Again, we talked about recycling facilities. They must be available to at least 60% of the population. If they're not, then the claim needs to be qualified. Claims that a product is made from recycled material need to be narrowly qualified to match the actual percentage and the content of the recycled material. And just like qualification in general, that is the theme of the green guides and the FTC's guidance as it comes to environmental claims, because the FTC essentially says, consumers are going to overthink the benefits of a green claim when they see them, whether it relates to recycling or otherwise, and that's going to cause consumers to pay more money, and it's going to cause them to buy your product. And if there are constraints, consumers deserve to know. And so your claims need to be narrowly qualified to match the substantiation and to reflect the real life possibilities and opportunities for consumers. Finally, though we will recommend, or I will recommend, maybe sometimes having a third-party audit or third-party certification to ensure the recyclability of your product. I must say that, the FTC doesn't let us rely on third parties alone, and so it does not eliminate our responsibility as marketers to ensure that we have the requisite degree of substantiation. So those are just some key points, and we can move to the next slide. And Gary.
Okay, thanks, Sarah. Next slide, please. So California has special legislation for environmental claims in general. And big picture, there are special substantiation requirements in California for your substantiation file that apply to any claim that the natural environment has been benefited by something you do or something you sell, or that something you do or sell is not harmful to the environment. Within that broader category, recycled, recyclable, and chasing arrows are specifically identified as subject to this substantiation requirement. Next slide, please. So the substantiation requirements are, okay, it's got to be true, which is aligned with the FDA, but they also include things you would not have in your FTC. I may have said FDA, I apologize. In your FTC file. Any significant adverse environmental impacts directly associated with the consumer good, any measures taken by the seller of the consumer good to reduce environmental impact, any violations of federal, state, or local permits associated with the production, and whether there's FTC Green Guide compliance, and then finally, whether any use of recyclable or similar recycling type words or chasing arrows complies with the California definition of recyclable in California. Next slide. So California standards focus on whether or not something is recyclable in California. So to the extent that you were thinking you would design your compliance program to look at national compliance, you need to consider the risk that if you don't have a separate evaluation of recyclability in California, you are going to be vulnerable to California litigation. And essentially, so the title of the presentation was Watch Out for the Speed Traps. So speed trap number one is watch out for national compliance regimes because they won't pick up California issues. Speed trap number two is the way California defines chasing arrows is any chasing arrow. So if you have a resin code that has a chasing arrow, rather than just a solid triangle around the resin code, that is considered a recyclability claim in California, no matter how small and out of the way that resin code is. And within the last fortnight, there have been 2 lawsuits filed in California. One of them had examples of this resin code issue in the complaint. Next slide. Okay, so how does California define recyclable in the state? Here's the definition in front of you. 60% availability, which tracks the FTC guides, but is California specific. And then 60% of the materials need to go into a defined recycling stream, which is also reasonably consistent. But California speed trap number 3 only focuses on large volume transfer facilities. So to the extent you are relying on a store drop-off recycling program that does not move the product directly into a large transfer facility, you have special risk under California law. Speed trap number 4 is California does not allow limited claims. So under the FTC guides, you can say recyclable in certain areas. In California, you cannot make a limited recycling claim under California law. It's all or nothing at the 60% level. Speed trap number 5 is that the recycled materials, when they enter the recycling stream, have to comply with the Basel Convention, which applies special conditions to what is considered appropriate handling of materials. And so you need a Basel Convention compliance analysis in connection with claims in California. Next slide, please. In addition to these special requirements that I've outlined, there are certain claims that are just absolutely per se prohibited in California. Speed trap number 6. You have to have your product comply with the APR design guide or it's not recyclable. Speed trap number 7. It can't contain any intentionally added Prop 65 chemical or it's not recyclable. Now, query whether these absolute prohibitions satisfy the First Amendment, but your compliance choice may be to litigate a First Amendment issue, which ain't cheap, or to follow these prohibitions. And then speed trap number 8 is not made from plastic or fiber that contains either intentionally added PFAS or PFAS over 100 ppm as measured by organic fluorine. Next slide. All right, so for those of you who are licensed in New Jersey, New York, Kansas, and Pennsylvania, please type and submit the CLE code recycling at this time. Please make sure you hit the send button so that it registers. In case you missed it the first time, the word is recycling. New York, New Jersey, Kansas, Pennsylvania. All right, back to Sarah for litigation trends outside of California.
Sure, and there might be some overlap here. So next slide, please. Okay, I'm going to be honest, a lot of these categories overlap. If I had created a Venn diagram, you might have seen that. I did not that proficient at PowerPoint, but there are similarities and differences and relationships that we can talk about as we go through these various types of claims that we're seeing against companies who are types of lawsuits that we're seeing against companies making recycling claims. So false advertising lawsuits from the FTC and in litigation, false advertising claims say, you made a claim, it wasn't truthful, it was misleading, and a lot of, on a national scale, we have the FTC Act, which prohibits misleading conduct, and then each state has a mini unfair and deceptive trade practices statute. And so in the litigation, you oftentimes see folks bringing claims under those state laws. Moving to class action lawsuits and the plaintiff's bar, they're everywhere, especially in California. But we're seeing a lot of class action claims against companies, and we'll talk a little bit more about that, but those can be brought by consumers. Those can be brought by consumers along with other entities, and they're suggesting that they are being damaged by claims regarding recycling that are untrue and therefore seeking remedy. Litigation from the government, we'll talk about that a bit. You're seeing various cities and states sue companies. I think, yesterday California got hit yesterday, California hit Coke and Pepsi, and a lot of the claims that are, or a lot of the lawsuits I'm going to talk about are other cities hitting Coke and Pepsi for claims that they're making regarding recycling and ways that those claims are impacting the city and the consumers in the city. The environmental justice claims, these are our cause crusaders who may or may not be there for the good of the environment. You can see overlap sometimes, again, in some of these class action lawsuits. They will bring false advertising claims, but you see environmental justice litigation. It also includes the litigation from the government that we'll talk about. Greenwashing claims in general, you're suggesting that your product is greener than it actually is. That can apply to recycling. That can apply to all types of green claims. And we've had sessions on greenwashing litigation in the past, but that is why the FTC has its green guides, is to try to provide direction and directives so that manufacturers and advertisers can avoid being accused of greenwashing. And at the end, I talk about corporate social responsibility obligations. We are seeing litigation when a business fails to meet its stated corporate social responsibility commitments, which can include recycling goals. So those are some of the types of claims that we're seeing. It's certainly not an exhaustive list, and as I said, it's fairly redundant. But if we move to the next slide, we can talk about just some recycling litigation, and Gary's going to talk about this more. But I put these three claims together because they all have some commonalities. They all focus effectively on allegations that extensive use of single-use plastic bottles contributes significantly to plastic pollution, and it misleads consumers about the recyclability of the products. And for example, it can create a public nuisance by polluting the environment. And they all say the companies have failed to adequately warn consumers about the harms of plastic packaging. And these are just, like I said, this is a representative sampling, and I included it here because you see Schwartz is being brought by a consumer. Also, I think Sierra Club is also one of the plaintiffs in that case. Mayor and City Council of Baltimore v. PepsiCo. I mean, there you have one being brought by the government. It followed a New York action. We have actions in California. This was just one example that we used. Oh, I really did. You won't be able to see it because it's blurred, but I have a Coke and a Pepsi can because I am double fisting with both of those drinks this morning. So I thought that was very on point with these as well. But finally, Earth Island, the Coca-Cola, same thing. This is a scenario where you have environmental organizations. We talked about those. Cause Crusaders, here bringing litigation, and we've seen that in California as well. So again, we talked about this a little bit, but the key attributes. The main concern here is plastic pollution. These are companies allegedly are all making misleading claims. They're saying their products are recyclable when the infrastructure to support the recyclability is not present. They include violations of these mini UDAP, these mini state unfair and deceptive trade practices statutes that we talked about, public nuisance statutes, product liability claims, and they say that the companies are responsible for the resultant harm because of the packaging. And what Gary will get into, and I think only one of my examples here shows, but California is a very common jurisdiction for this type of litigation, and I don't want to step on Gary's toes, but as I said, I'm relatively new to California, but I have learned that it is a very litigious state and that they are ready to go. And so here I am, and maybe this was a good career move for me to move here, but there are a lot of economic factors at play when you're making recycling claims, and in general, we're being told that those claims are false. So I'm happy to speak at length about any of these three lawsuits, but I won't unless we have additional time. We can move to the next slide.
Okay, thanks, Sarah. So back to California. Um, this is kind of slightly chronological, and we could add another bullet this morning that I'll talk about. But one of the early significant lawsuits about recycling was an allegation that the Keurig coffee pods were not getting recycled because they were too small to be filtered out of the waste stream or filtered in any way um, in order to be segregated and put in the recycling stream. So Keurig argued that the pods were recyclable and that's all they were saying. But the plaintiff argued that in a world where the key machinery cannot filter out the pods that Keurig makes in order to actually get them in practical terms into the recycling stream, a claim about theoretical recyclability was not truthful or was misleading. So after a few setbacks in the law and motion practice, Keurig elected to settle that matter for $10 million. It was about 6.5 to the class and about 3.5 to the lawyers and the plaintiffs. There was another lawsuit at around, in the early recycling time, allegation times in recent years, where plastic food items, forks, etc., cups were described by Walmart as being recyclable, and they were sued in California in a proposed class action. Walmart successfully defended that, arguing that the plaintiffs had not suffered as a result of these claims and could not demonstrate standing under the California law. And so that, after a year and a half of law and motion practice, was an unsuccessful recycling class action, defeated essentially on standing under California law. We talked about California's special rules for what is recyclable in California. We talked about those specifically. We talked about those in general terms with respect to consumer goods. However, there are also California-specific laws about what's recyclable in California that specifically relate to the bags that you put your groceries in at the supermarket, and that specifically relate to takeout materials for quick serve restaurants. So because there are these special rules, a substantial number of major supermarket chains have been sued for failure to comply with the special definition of recyclability in California. These rules have rolled out earlier than the general rules, and same for quick serve. There are special rules, special prohibitions, and so you've seen at least 2 quick serve restaurants be sued, one within the last 10 days. Then there also was a lawsuit that garnered a bit of attention that many of you may have heard about, which is our Attorney General, Rob Bonta, as well as some other public interest groups, sued Exxon for falsely promoting recyclability as an answer to the plastic pollution crisis, as opposed to a a slice of addressing the plastic pollution crisis that would be helpful but not solve the whole thing. So that complaint was extensive, has just been filed, and we're in the early days of that litigation, but there is the allegations against Exxon go back 10 or 15 years and are extensive. And so I would expect that to be a hard-fought case for several years at least. Now, as a child of that same type of over-promising recycling as an environmental solution, yesterday, the Los Angeles County Council, on behalf of the people of California, filed a lawsuit against Pepsi, Coke, and the largest two bottlers, one a Pepsi bottler and one a Coke bottler, alleging that they made claims about the overall goodness of their recycling programs and how people needn't worry too much about plastic pollution because the availability of recycling is a counterbalance. So we may see additional lawsuits like this. There clearly is a playbook now, not only for Exxon as the manufacturer of the plastic resin, but also for consumer product manufacturers. And keep in mind, Coke and Pepsi sell products into a recognized and established recycling stream. Their plastic products have among the highest levels of recyclability in the marketplace. So if they're getting sued, it is unlikely that the litigation is going to end with lawsuits against Exxon, Coke, and Pepsi. Just kind of, again, this, and I apologize, this is a little bit of a repetition of what Sarah has already flagged, but just to give you a concrete example of some of the allegations, here are kind of the headings in the table of contents of yesterday's lawsuit against Coke and Pepsi, that they repeatedly presented themselves as sustainable companies, but they weren't, that they pushed recycling as the solution to excuse and address single-use plastic packaging when it's not a complete solution, and allegations that essentially that the scope of their promoting of recycling extended beyond the capability of the system and therefore was misleading. So another interesting example of the allegations in the complaint, and I'm not commenting on the truthfulness of these allegations, I'm just providing them, was that circular economy claims are misleading because plastic materials in most cases can only be recycled once, not multiple times, as a circular economy claim would suggest. And the failure to describe problems with microplastics also rendered these claims misleading. Next slide, please. So Sarah and I are both going to talk a little bit about the practical considerations for companies in light of the litigation and the statutes that we've presented. Next slide. So hopefully with the description of speed traps and the description of litigation, you are taking away from this presentation that one must be very careful about recycling claims. Think about them in the context of overall claims of sustainability. Think about them in the context of do you have a substantiation file for California specifically? Think about them in the context of the California specific prohibitions on recycling claims, and examine your risk profile, and over the next 5 or 10 years, think about, so California is going to generate reports every 3 or 4 years over the next 10 or 15 years that identify what clears the 60% threshold in California and is therefore recyclable in California. A draft of the first report was released at the end of December of last year and is now undergoing public comment. That report, when finalized, will initiate an 18-month period for companies to bring products in compliance with these recyclable in California restrictions. And so consider what is in the draft report, consider what claims you want to make over time and how you're going to get there, and be working in all of those areas. Next slide, please. We are not really going to talk about the California's dramatic legislation on single-use packaging, which addresses plastics and paper and cardboard and other packaging materials that are single-use packaging. But it is worthwhile to note that these recycling claims come in the context of a significant effort on the part of California to reduce single-use packaging that is going to, tax and regulate substantially over the next 10 years, if not longer. Next slide. Sarah, back to you for best practices.
Sure. Okay. So one thing I realized is that during the course of this presentation, Gary and I have frequently alluded to the term substantiation, and that's just a really fancy word for support. When you make a claim, you have to have a reasonable basis for that under FTC guidelines. When you make a claim, you have to have a reasonable basis to make that claim. When that claim deals with health or safety, you have to have competent and reliable scientific evidence to support that claim. And so when we talk about substantiation, and it's my third bullet point on this particular slide, we're talking about the evidence that you have to support the claim. And I'm calling it a best practice, but it is a necessary practice, is that you have that substantiation in pocket before you make the claim. Don't make the claim and then go seek to find the substantiation later. This is not a retrofit solution, and in recycling, it would be particularly difficult to make a retrofit solution. But make sure that that substantiation is in pocket once you make the claim. So best practices, to go back, the FTC guidelines, the green guides, they are like my Bible of environmental green claims on a national scale. I always say I was into them before they were cool, like back in 2012 to 2013, before all of this greenwashing happened. I mean, I found them to be very fascinating. There's a lot of work that needs to be done by way of this new revision that we're all very much looking forward to. But the FTC guidelines, you should familiar yourselves with the green guides. Your claims at bottom under Section 5 of the FTC Act and under all of the state mini UDAPs must be truthful and not misleading. Be on the lookout for the new updated green guides. I was recently at a conference where we kept trying to get insider information about when we would see them, and we got no concrete answer, but they should be out at any point. Obviously, the state regulation, right now we do not have harmonization totally between the federal law and state law. Although I will tell you, a number of states have modeled their guidance on the green guides and their statutes and their legislation, including California. California just has added more to the green guides. But, at this point, you need to make sure you're familiarizing yourself with the state-specific regulations, particularly in California. For education, I spoke previously about questions about whether you're making an advertising claim or whether you're giving instructions. We tell manufacturers, consider including information where you can, where it's legal and permissible, obviously where you meet that 60% threshold, and in California, that's where the analysis ends. But consider providing the requisite instructions on how consumers can recycle a particular product. Obviously, monitor litigation trends. We've talked about them. We're seeing them everywhere. Plastic manufacturers, and these are, as Gary said, the manufacturers that have among the most recyclable of the products. They're also really big players. But we're seeing them, and we're seeing them come from all sides. And so be aware that they are here, and they don't look to be slowing down. They only look to be speeding up. What did Gary say, 2 in the past fortnight? And I'm sure there will be more to come. And prepare to be scrutinized. Look, you don't typically feel the pressure until it's there. If I had $1 for, I could even take a penny for any time a client said to me, but they're not doing it, but they're not doing it, but they're not doing it. Why do I have to do it? Why am I being held to a standard that my competitors aren't being held to? And the fact of the matter is, that maybe potentially your competitor that is sitting on the same shelf isn't looking at this as seriously as you may. Does not mean that that is okay. And what really becomes a problem is when you get tagged, for example, by the FTC or the plaintiff's bar or whatever it might be. So if you go in there preparing to be scrutinized, that is always helpful. Next slide, please. Okay, so you need to avoid, part of the advertising and that we recommend is truthful and not misleading. And what do we need to do? Like, the reasonable consumer needs to understand what you're saying and what you're conveying, whether that relates to recycling or anything else. So again, avoid consumer confusion, be precise. If there is misinformation that has made its way into the public, address that misinformation. Like Sarah Carlson, I was Sarah Schneider 20 years ago. I was Sarah Schneider, and my mind would have been blown to know that I couldn't recycle all plastics. Like, college Sarah Schneider was just throwing all of her plastics in the plastic recycling and had no idea about the fact of the matter, which is that, okay, not all plastics are recyclable. They can't all be melted down. They can't be reused. What about the number of times of use? So, address misinformation, and then be clear and conspicuous, right? You can't hide things. I think Gary was talking about in California, it doesn't really matter where you put the 3 chasing arrows, or I call it the Mobius loop, on your product, that, standing alone, you just can't do it. And that's very similar to the FTC. If you put a Mobius loop on your product anywhere, that basically, the FTC says that consumers believe that your product is 100% made of recycled material and 100% recyclable. Just from those 3 chasing arrows, that's what consumers Derive, and Divine. And so I wanted to flag the Mobius loop issue, but be clear and conspicuous about your disclosures, your disclaimers in general, what you can and what you can't do. Don't forget to consider the availability of recycling facilities. I look forward to receipt of information, having some form of a clearinghouse where we can all look and see and ensure that there is availability. Get back over the Mobius loop. Be precise as to your claims. Hit on that earlier. Look, whatever claim you make, it needs to be narrowly tailored to match your substantiation under federal law. And so, and federal laws, as I said before, the federal government believes that consumers reasonably interpret environmental claims to be much broader than they are. And consumers are handicapped because they cannot test on their own the validity of the claim. They cannot, they do not have the means to ensure that your product is recyclable or biodegradable or whatever the potential claim might be. They don't know. They're just going to spend a little bit more money. So you need to ensure that you are narrowly qualifying your claims to meet the substantiation, and that's something that we can definitely help with. And again, consider whether the actual type of material will be accepted. Don't be Sarah Schneider 20 years ago who thought if a bottle was made of plastic, we were good. You have to think about what is that type of material that's being incorporated into your product or your packaging before you are willing, able, and ready to make any type of claim. Next slide, please. Okay, some of these are duplicative, and for that, I apologize, and I will not hit. But the standard is the reasonable consumer standard. What does the reasonable consumer believe when they see your messaging? Not the unreasonable consumer standard, although the plaintiff's bar is able to get away with some pretty unreasonable hypotheticals, likely past the motion to dismiss stage. So, be aware that even making claims that, or even twisting claims and making them unreasonable you can still land in court with the plaintiff's bar. One other thought is that you might want to provide accessibility to the claim support that you have, whether that's online accessibility, just so that consumers and others are able to see the substantiation. There are times when that's good. There's times when that is not as good, but it's something to contemplate. I'm going to tell you to consider third-party claim certification where it's helpful. I also told you about 10 slides ago that you can't rely on it. So consider it, but you can't solely rely on it. You are responsible for your claims. Let's talk about this next one for recycled content claims. Oh yeah, Gary, go ahead.
Thank you. Yeah, the third-party claim certification, I would just add to what Sarah has said and note that I think it's helpful, but if the certification process is a black box to you and the certifier won't really tell you all the information they relied upon, that is problematic. Black box certification is concerning and less helpful. But explained, detailed, fact-based certification can be quite helpful and can be, you're not, in that instance, you're not relying on merely the certification conclusion, but you're relying on the certification analysis and the facts in that analysis. So I offer that as a footnote to Sarah's helpful comments.
I could not agree more. As it relates to recycled content, the reason I flag that is the FTC requires companies to distinguish between pre-consumer and post-consumer recycled content. And what do I mean by that? I mean, there's some recycled content that never makes its way to the consumer. It's waste that is generated during the manufacturing process itself that would otherwise be tossed, but that can be reincorporated into a new product. So that's like a pre-consumer recycled content claim. A post-consumer recycled content claim is the product has been used by a consumer, right? And after that use has been diverted from the waste stream. And the FTC does care about the distinction, and failure to properly qualify will significantly impact what the FTC believes the reasonable consumer will divine from the claim. So always remember to consider qualifying your recycled content claim. We can move to the next slide. Okay, so another best practice consideration is, train your employees on what they can and can't say. This is not just a plug for me and Gary to come speak to your employees, though we're happy to. But this is because it's very, you don't know until you've been tagged. And there's certainly a lot of misinformation out there, as we've talked about, as to what is and what is not can be considered recyclable. And many folks, I am sure, are completely and wholly unaware of the 60% threshold, for example, or the various types of plastics or what it might be. So if you have a green marketing campaign that includes recycling claims, make sure that your employees are aware of what they can and can't say. That can include interactive sessions, that can include coming up with curriculum, it can include online training, it can include expert speakers. You just want to make sure that folks aren't navigating in the dark when it comes to the types of claims, because the worst is when you get a claim from marketing and they think it's really great and cool and the ROI is going to be incredible, and then you have to be that like dream killer. So better to let marketing know in advance as to what they can or can't say. Ensure that there is some team within your organization that has ultimate accountability over what makes it out the door. That's a pretty easy one, but you'd be surprised at the number of times that I realized that the legal department only has learned, maybe not surprised because I'm preaching to the choir, but the legal department only knows about the claim after it's gone to press. So have accountability before it goes out the door. That falls into an internal review process. And as you're thinking about claims going forward, I'd also think about the claims you've made going backwards. So you can, we suggest going through your existing marketing, your packaging, your labeling, your collateral, and ensuring that you have the proper substantiation for that claim. And that can be a very in-depth, time-consuming substantiation review, or it can be a scenario where you go through the claims that your company is making and sort of triage what you think are the most alarming of the claims or the most potentially harmful, and start there and work your way backwards. But oftentimes we forget what might have been put up on our website years ago. In this case, something that might have been put up that was compliant with the 2012 guidelines, but that will not be compliant once those revised green guides come out. As you can tell, I'm like a kid on Christmas Eve. I cannot wait for these guidelines. But once they come out, things that you said previously, you're not going to be able to say again. And this is last bullet point is similar to what Gary was saying as it relates to this third-party certification. Knowing what's happening, not having it be a black box, just know what's happening in general, right? When you're reliant on a third-party entity, or when you're reliant on someone up or down the supply chain, you need more than someone just saying, yeah, we're good. I mean, that's like, what I get out of my 14-year-old son, like, why are we good? I want to know what's happening. And so ensure that you're engaging in discussions and helping to suss out why we are good, in other words. Next slide, please.
Before we turn to that, I noticed that there was a question about retailers in the question column. And that raises some interesting best practices discussion. retailers are not considered liable under the California laws for claims that are made by a brand that they don't own, but they are responsible for their house brand, even if they're outsourcing the labeling of that house brand. Where we have seen retailers and others face issues, especially, is if the law department is reviewing the labels, but the law department doesn't have visibility into claims that are made on X or on the website, and the person who is entering the website material or the social media material doesn't have a nuanced understanding of how one might get in trouble for some of these claims. So I would guide everyone to be careful about your internet and social media collateral, because plaintiffs are combing through it. We have seen district attorneys in California comb through it and follow up. And and that is one way in which retailers sometimes also have found it to be their issue because it was their website and a claim that was made on their website. And then I would just note that retailers like brand owners, to the extent that you all are making general circular claims, general other claims, the substantiation for that claim may be challenged in the same way that Coke and Pepsi are being challenged for their substantiation. So bear that in mind. Back to you, Sarah.
I'm happy. I actually have a script for the closing. I did not author this, but much like the script at the beginning, I've been told that I must say it. So thank you all so much for joining us and participating in today's CLE webinar. In approximately 30 business days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you're seeking credit in Kansas, New York, New Jersey, or Pennsylvania. Have a great day. Do we have any other questions? If not, I think we can call it.
Thanks all. Take care.
Thanks, everybody.